fire up across the internet and let's see where we're at. So it's looking like we're live now on Periscope, also on Facebook, and we're there on YouTube. Hello, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group. We're a small law firm in Scottsdale, Arizona. And over the course of many years, my team and I, we've helped many thousands of people facing criminal charges through the criminal justice system. I'm talking specifically about people with DUIs, drug offenses. We've represented a lot of traffic types of cases, but a lot of the more serious offenses as well. Things like sexual assault, things like actual murder, and some of those more heinous offenses. So we've basically seen it all, handled every type of case in almost every single court throughout the state of Arizona. And over the time in practice, we have unfortunately seen a lot of problems that permeate the criminal justice system. Misconduct involving police, prosecutorial abuse. We've got judges abusing their discretion. We've got politicians who are helping to sort of steer the focus of injustice wherever they seem to make it want to fit. And so what we have done, because we have seen so much of this, is we decided to start this program called Watching the Watchers, where what we want to do is hold those people accountable, hold our elected officials, our police officers, our politicians, our prosecutors, anybody in the justice system. We want to make sure that they're playing by the same rules, that they're following the rules that you or I would be subject to were we going through the justice system. Because unfortunately, what we are seeing often is that there are a lot of bad guys in our justice system, and they're masquerading as the good guys, and they're hiding behind a gun and a badge to do it. So we want to hold them accountable. We think that the only way we're going to see meaningful reform in our criminal justice system is through transparency. It's through shining a bright light down that just helps disinfect a lot of the malfeasance that is going on. So if you're not a regular of the channel, you're just joining us here for the first time, do us a favor, hit the subscribe button. We go live every day at 4 p.m. Arizona time, 7 p.m. Eastern time, and we'd love to have you here. Jump on into the live chat and get to know everybody else who is there, because there are a lot of important issues that we want to talk about. Specifically today, we're talking about Breonna Taylor. We've been covering this story ever since it happened. We've been very, very detailed covering this since day one. We knew that this case was going to be something that was going to be, in my mind, problematic just from the original facts of the case. It was not a good situation. And remember, Breonna Taylor's case started before this new sort of justice reform movement really got underway after George Floyd's death. So we've been covering it for a long time, and it just doesn't seem to ever conclude. Now we have news stories from a lot of the people who were on the grand jury. They actually gave an interview with a news agency, and they said a lot of the stuff that we had talked about on this channel, a lot of the problems that we suspected were occurring during the grand jury proceedings, well, they're true, because the grand jurors are now coming out, speaking anonymously, and they're explaining what happened. So we're going to dive into that. We've also covered the Matthew Dolloff situation. Remember, this was the supposed security guard who was out there protecting a news person and got into an altercation with a gentleman by the name of Lee Keltner and ended up shooting and killing him. And today, we have an update on that story, because he was trying to get his bond reduced, and we're going to tell you what the judge had to say about that. Then at the end of the show, before we jump into the live chat, we want to give you an update on 2 Supreme Court cases that are going to impact how this election proceeds, specifically out of North Carolina and out of a major, major competitive state, Pennsylvania, where the Supreme Court issued some new rulings late last night, and I think even early this morning, that help dictate how those states are going to manage their election. So, and we actually see that one of the states changed. If you remember from our previous analysis, we gave one of these states to one candidate, and that is actually flipped, in my opinion, as a result of what we saw in the Supreme Court case. So let's dive into it. Once again, thank you for being here. We're starting off with Breonna Taylor. You may remember the officers who were involved. These 3 gentlemen here: Brett Hankinson, we had Jonathan Mattingly, and we have Myle Cosgrove. Now remember, Brett Hankinson was the only one who was actually charged with anything. That's this fellow here. He was the only one who was actually charged with a crime. The other 2 were not charged with a crime. So we see that Brett Hankinson is there on the left. Jonathan Mattingly, if you recall, just to give you a quick recap, Jonathan Mattingly was the first officer through the door. So as a refresher, Breonna Taylor is in her apartment with her boyfriend, Kenneth Walker. They're there late at night. these 3 officers and some other people supposedly around the facility do this warrant, execute the warrant, go into the residence. They wake up Kenneth Walker, who's inside the residence. That's Breonna Taylor's boyfriend. He fires some bullets over at John Mattingly, shoots John Mattingly in the leg. Miles Cosgrove was right in the door, right behind John Mattingly. So Mattingly's in first, Cosgrove is in second, and then Brett Hankinson over here is still on the outside of the residence, and he starts just discharging his firearm. He just starts firing it into the apartment complex because there is a sort of back and forth bullets going in multiple directions. Kenneth Walker's firing towards the officers are firing back, and Brett Hankinson is outside. Now, the only officer who was charged was Brett Hankinson, and he was charged with wanton endangerment. No other officers were charged with anything related to Breonna Taylor's death, and in large part, what we saw was the reasoning why they weren't charged is because, according to the Attorney General, Daniel Cameron, the grand jurors didn't want to indict these officers. They heard the facts, and supposedly they decided there's not enough evidence there to charge the officers. That's according to Daniel Cameron. Well, a lot of that stuff was kept under seal. Judges started requiring that the transcripts get released, and then also approved that the grand jurors could now actually speak out. So even though Daniel Cameron and the government may have thought that this whole thing was over and had been whitewashed and thrown under the rug, that's not the case, because the grand jurors are now speaking out. And as a quick refresher, remember, Brett Hankinson, this guy who was charged with the crime, he was charged with a crime that in no way was related to Breonna Taylor's death. It was only related to firing bullets wantonly and recklessly throughout the apartment complex. And specifically, the complaint named the neighbors who were in the apartment adjoining Breonna Taylor's apartment. So still very little justice for Breonna Taylor or Kenneth Walker, in my opinion. None of these officers were charged for any crimes that related to either of those 2 individuals. They were related to neighbors next door. And so there's been a lot of concern that justice is just not being done in this case. And we had very recently, we have an interview that took place over on CBS this morning. We've got 3 or 4 clips from this. So for this next segment, it's going to be a little bit clip heavy, but it's because it's so good. There's a lot of information that we get out of this interview. Now, as a reminder, the grand jurors who are going to be communicating here with this news anchor, they're all speaking anonymously. They don't want any repercussion coming back towards them. Anytime that you sort of challenge the government, people start to get concerned about that. Daniel Cameron's the Attorney General. There's a lot of other officers who are part of, sort of this blue shield, this blue code of silence, this fraternity of law enforcement officials. And so anytime that you start to go after the police, specifically, if these grand jurors come out and say these 3 cops are all responsible for crimes, they may fear that they're in danger. They still live in those communities, and they don't want the police to be harassing them or following them around, or they don't want the complaints just from the general public, right? There's a lot of people out there who are, sort of viciously pro-police. No matter what they do, they're going to side with the police. I think that's a sort of a mistaken way to view the world. I think that most people should have independent thought as it relates to these issues. We can review the issues individually, case by case, but there is a big contingent of people in this country who say all the police are bad, and there's other people who say all the police are good, when really I think it's somewhere closer to in the middle. So enough of that. Let's go take a look at some of these clips, because there is some good content here. Again, this comes from CBS this morning. Let's listen in on this first bit.
Told us authorities never presented them with the option to consider indicting officers on more serious charges for Taylor's death, which left them feeling frustrated, disgusted, and even betrayed. Now, we're not revealing their identities at their request for their safety.
They didn't give us the charges up front. When they gave us all of that testimony over 20-something hours, and then to say that these are the only charges that they're coming up with, it's like, well, what did we just sit through? And then to be told that we're not charging them with anything else, to me, it was a betrayal.
So when you all look, Juror 1 and 2, and you're told that the only thing you need to consider right now is wanton endangerment, did anyone say, hey, are there any other options here? Did either of you say that?
Almost the entire room.
What was the answer that you were given?
Basically, in a nutshell, they said there were other possible charges that we considered, but nothing that we could make stick.
They never gave us the opportunity to deliberate on anything but the charges for Hankinson. that was it. As a matter of fact, when they announced that those were the only charges, it was an uproar in that room. There was several more charges that could have gone forward on all of those officers, or at least the 3 shooters.
Why is this so extraordinary, Kevin?
Normally, the grand jurors are presented with the law and the charges so that they can listen to the facts with an open mind and apply those facts to the law, almost as a roadmap.
What happened here?
What happened here was it was done in the complete reverse.
What stands out to you the most?
From a legal perspective, it looked like they weren't following the grand jurors, and they only wanted the grand jurors to follow them, which is contrary to the actual rule.
Grand juror number 1 and number 2 say what prompted them to ultimately speak out was that press conference held by Kentucky Attorney General Daniel Cameron, which they insist falsely represented their position on potential indictments for the officers involved in Breonna Taylor's death.
All right, so we got a lot, long clip there, but this is exactly right, and that defense attorney was on point, and the grand jurors were on point. There's nothing there that I think is off the mark. They all recognized that something was wrong during those grand jury proceedings. The way that we kind of ordinarily would explain something like this, a grand jury proceeding, it's kind of a fact-finding, an independent investigative body. And we're going to hear from Daniel Cameron. We got a couple additional clips of it. But basically what you're looking at is it's like you're a kid and you're playing with one of those boxes that has the different holes in it. You've got a triangle hole and a square hole and a circle hole and a rectangle, hole, or whatever the different holes are. I don't have any kids, but what you have is, you take the blocks and you find it. You put the square peg in the square hole. You put the round peg in the round hole. And that's sort of what a grand jury proceeding is supposed to be. You bring, all the different law and you bring all of the different facts, and the grand jurors are supposed to match them up. They say, okay, we have this little round peg here, and that feels like this set of facts. Let's see, does that fit this law? So this law is a square law. Does the round? No, that doesn't fit. Does it fit in the triangle? No, that doesn't fit either. And so maybe let's try, okay, here we go. We found this law that matches these facts. It fits. And then they'll put the peg in the hole. Now, that is how it should go. And the grand jury should be free to go out and say, well, what other pegs do you have? What other blocks do you have? What other holes do you have that maybe this will match? And then they review the facts and they match them up. In this case, it sounds like what Daniel Cameron did is they just came in. They said, hey, we got one hole and we got one peg. We got a round hole and a round peg. You guys better find that it fits in there. And if you ask for the square peg or the square hole, you're not getting it. That's not how it's supposed to work. And the jurors seem to have recognized that. So when they said that they were only going to be bringing forward the wanton and reckless charge against Detective Hankinson, as we just heard from that grand juror, the whole room sort of was in uproar. The whole room was, what? There's other stuff here. And so they knew independently that there was something missing. But as we're going to hear, none of this stuff was addressed. We're going to find out. Remember, so they were originally upset about Daniel Cameron's press conference, which we covered at length here. And I want to just play a quick clip from that so you have a refresher on what he said specifically, because there is dishonesty in this statement as far as I can tell. Let's listen.
While there are 6 possible homicide charges under Kentucky law, these charges are not applicable to the facts before us.
Why not?
Our investigation showed, and the grand jury agreed,
there it is,
Mattingly and Cosgrove were justified in the return of deadly fire.
When he stated that there were 6 possible murder charges and that the grand jury had agreed that those didn't apply, the first time I heard the word 6 possible murder charges was in that news conference.
It wasn't presented to you in the grand jury deliberations?
No. And personally, when I do something, I take responsibility for it. We had not done that.
I really felt that. This was all Cameron. This was up to him. We didn't get a choice in that at all. So I was livid. By the time I heard what he was saying, everything that came out of his mouth, I was saying liar, because we didn't agree to anything. We never met Cameron.
You've never met Attorney General Cameron?
No, we never met him. He never discussed anything with us.
I think many people will be very surprised to hear that they had no contact with Attorney General Cameron whatsoever.
Yeah, I'm not surprised by that. I don't know why why they're surprised by that. Daniel Cameron is somebody who is just the figurehead of this whole thing, and it became a lot more political in my mind than it needed to be. This was not really intended to be something that was a fact-finding investigation. What we saw was a very sort of, I think, thrown together investigation after the fact. We saw a lot of malfeasance that took place. This information really didn't come out until the public demanded that a lot of the investigations took place. We saw a lot of misconduct, in my mind, from the police officers. Remember specifically that Detective Hankinson went over to the hospital to have a conversation with Mattingly after he was shot, which is completely out of the ordinary. So a lot of this stuff was problematic and had been problematic for a long time. Daniel Cameron was just the captain of the ship to, kind of weasel this thing through with the minimal amount of damage. Now, ordinarily, he would have gotten away with it. I mean, in most situations, the grand jury proceedings are quiet. There's typically not a lot of public interest in a lot of these cases. Breonna Taylor was one of those that caught national attention, and fortunately, there was enough public pressure to make sure that the lens was really down on this case so that we could see what was going on. But in most cases, this type of stuff just goes right under the radar. And so what if you were in a position where, you're indicted by a grand jury and this type of conduct is going on? I can assure you it's not just going on in this one case. It's probably going on in other cases throughout the state. So this is a major problem. And the grand jurors themselves are saying, I didn't use the language. He said he's a liar. He said, I couldn't help but think that he's a liar. Because he did lie. If he didn't present those 6 different homicide charges to the grand jury during their indictment proceedings, then he is manipulating the purpose of the proceedings. He's not giving them all of the different pegs and all of the different holes. He's just saying, you get this one peg and this one hole and you better make it fit. And don't ask about any of the other stuff because we have already decided. Now, you see how he did that when he said, our investigation revealed that these different charges weren't justified and the grand jury agreed. No, they didn't. They didn't have an opportunity to agree because none of the evidence was actually presented to them the way that it should have been. And it's really a miscarriage of justice, right? This is what we're talking about when we say that there are 2 different levels of justice. The police get one set of rules. Everyone else gets a different set of rules. The police, had this been any other situation under similar circumstances, those police, in my mind, and a reading of the statutes, they would have been indicted, or they would have been, maybe not for her murder, but for some sort of recklessness, for some sort of, misconduct related to her death, like a negligent homicide or something to that effect. But that didn't happen here. Not because the facts don't match up. We already went through the facts. We've covered the facts ad nauseum on this channel. Spent a lot of time on the Breonna Taylor case. And now they're just going to walk away because the prosecutor's office did an investigation into themselves, which is the police department, which is an extension of them, and they found that they did nothing wrong. And then they basically coached the entire proceeding. They manipulated it to get them the result that they wanted. That's what happened. And the grand jurors are now confirming that. We have a couple more clips from this interview because like I said, there's some good stuff here. Let's listen in on this one.
I think there was enough evidence to present charges of murder, attempted murder, manslaughter.
Yes, I think there was. Yeah, I mean, just all of the evidence there. As we were listening to it, we were sure this was leading up to something like that.
Among the
Yeah, I mean, that's what we were all thinking too, and that's what we were hoping to see, at least something that would have implicated either one of those 2 officers. And we went through it. There are a lot of problems with this case. It sounds like the grand jurors were also aware that, this was probably coming, and then they were surprised when it didn't come. Now, the reason why they're saying they're sort of surprised and why they spoke out, one, because Daniel Cameron lied during the press conference. He said that they did consider these when they didn't because they were never given the option. But then they also had some problems with the officer's credibility. This is from the 911 call from Kenneth Walker. So Kenneth Walker was Breonna Taylor's boyfriend. He was at home in bed, and the police broke into his home. He fired some bullets their direction, hit one of the officers. They fired back. They killed Breonna Taylor. Kenneth Walker made it out alive. Now, remember, at the very early days on this case, they charged Kenneth Walker with attempted murder for firing back towards the police. Those charges were later dropped in large part because he was in his home. if you're in your home and somebody breaks into your home, you have the presumption of self-defense. Just because they're cops doesn't mean that you lose that presumption. So they tried to charge him on top of this. There's all this misconduct going on, and they try to charge Breonna Taylor's boyfriend after they kill her. He was firing back, and they said, no, that's not self-defense. That's attempted murder. So in my mind, they were trying to, not only did they kill Breonna, but they were trying to cover their tracks by actually charging her boyfriend with attempted murder. That charge later got dismissed because the law says that when you're in your home, you have that presumption that you use self-defense. And so they couldn't prove the case. So Kenneth Walker's case gets dismissed. But now what happens to Breonna Taylor? We still have a dead young woman and no charges that relate to her death. Not a single one. Detective Hankinson was charged, but he was charged specifically in the complaint for firing bullets at the neighbors. So when the cops listen to some of this stuff, they're saying there is no credibility at all. And one of the things the grand juror spoke about specifically was this 911 call from Kenneth Walker, where you can hear in his voice, he has no idea what actually was going on. Let's listen.
911, Operator Harris, where is your emergency?
I don't know what's happening. Somebody kicked in the door inside my girlfriend.
The thing that stood out to me when I was talking to him, he said, why would I call 911 if I thought it was the police?
That resonated with me because he didn't know who it was that was coming in. You know, he had no idea. You could hear the distress. Everything about what he said was believable. It made sense all the way through.
You found him credible?
Yes.
Totally believable.
Did you find the police credible?
No.
No, there are too many inconsistencies in their story.
That's
I
right.
understand that, you know, in a situation like that, you may not remember, but I didn't find their testimony credible.
What was your understanding about what happened that night?
It was a mess. It didn't seem to me that there was any organization or almost any leadership in the whole operation.
From the evidence that I heard, this thing started out downhill to begin with. You don't need 7 cops to go up to somebody's door and knock on it and say, you know, we're here to do an investigation at 1 o'clock in the morning. It kept going downhill from there. It was one mistake right after the other one, right after the other one. They covered it up.
Yes, they did.
That's what the evidence that I saw. And I felt like there should have been lots more charges on that. They covered it up.
100% right. 100% right. And finally, that grand juror is coming out to speak. So, you know, I'm sure that the news agencies vetted them and that these are who they say they are. And, you know, the alternative argument from a lot of people who are, you know, all cops are always good and never do anything wrong, that type of people, they're saying, well, this is all buyer's remorse. You know, this is all, they heard the facts. They had the opportunity to make some adjustments to their decisions. They didn't do it. And now they're just out there trying to milk it, you know, trying to milk the media, or they saw the response and they didn't want to be a part of, you know, the public outrage. They didn't want to be a part of the cause of the fact that Breonna Taylor's killers didn't get indicted. You know, they don't want to be a part of that. So now it's sort of, you know, 2020 is hindsight, woe is me after the fact type of, now I'm going to go and try to right the record. But in my mind, this has been sort of a corrupt bargain the entire time. We have been seeing that the evidence that has been discussed and a lot of the material that's been released has been completely one-sided, and we had our suspicions that the grand jury proceedings were bad just from being outside observers. We have covered it at length here, but now we see that on the inside, it was a problem. One of the things that we had spoken about, quick refresher, was this idea that Detective Hankinson actually went to the hospital. We went through the procedures. They're not supposed to have contact with any other people there. And we saw here the person who's questioning this individual says, were you surprised he was there? He says, yeah, it's just so contrary from what I've seen in my previous officer-involved shootings. I mean, they are, you know, in my experience, is they're brought here to the public integrity unit by, you know, members of this unit. Okay, so, and he says, and I was surprised that had occurred. And he says, what? Right, that he was at the hospital? Yes. So Detective Hankinson, after the shooting, went over to the hospital where John Mattingly was, who was the first one through the door, and they had a conversation. What did they talk about? And you may remember that we also had a video that when Detective Hankinson fired his bullets, he tried to walk inside the building, and some other officer said, hey man, you can't be in here. You were involved in a shooting. We have rules to follow. You don't get to come and contaminate the scene and start manipulating things. You got to stay outside. So we have a number of instances where these officers are breaking protocol. They seem to be doing it knowingly. They're having multiple conversations about this. They tried to actually charge Kenneth Walker with the crime, and then the whole thing was just whitewashed by the Attorney General, Daniel Cameron. Now, this was Daniel Cameron himself in a past interview. Now, this is one we had a lot of criticisms with when this first came out. This is Daniel Cameron, an attorney who is the Attorney General for the state, coming out and saying that a bunch of civilian non-lawyers who have probably never sat on a grand jury proceeding before, that they should know how this works. That they should have done more. They should have taken more responsibility on investigating this and asking the right questions. He says that they're an independent body. If they wanted to make an assessment about different charges, they could have done that. But our recommendation was that Mattingly and Cosgrove were justified in their acts and their conduct. All right, so let's listen to this clip because it's ridiculous. Here is Daniel Cameron.
They're an independent body. If they wanted to make an assessment about different charges, they could have done that, but our recommendation was that Mattingly and Cosgrove were justified in their acts and their conduct.
And Cameron says,
yeah, so, the fact is the grand jury, they did intend to look at more things, but they were just limited because they only brought out the square peg and the square hole. They were told that none of these charges were applicable. They were told that none of these charges would be, something that could be held up in court. And they didn't even meet Daniel Cameron. Daniel Cameron was just, sort of the puppet master organizing this whole thing from his office. And since these grand jurors have spoken out, Miss Faith, who helps me do my show prep, she's right back there in that room right there. She has tried to scour and see if we had a statement from Daniel Cameron, and we just simply have not at this point. So I'm curious what his response is going to be. He got called a liar by that grand juror. The grand juror came out and indicated that this whole thing has not gone the way that it should have gone. They're missing some charges. They weren't ever even floating the idea of the homicide charges because the Attorney General and his office had already decided. They took the decision process away from the grand jury. They kept it on themselves so that they could help craft the result. So this actually came from another news clip from, looks like Law and Crime Daily, and they're talking specifically about the Breonna Taylor killing, about how a grand jury should work. Let's listen.
This was a very unusual case, Aaron. The fact that these grand jurors are coming out and speaking and saying to the public that this isn't what happened, and the fact that they hired an attorney to help them reveal what happened is also quite unusual.
And Brian, the grand jurors also said they found Taylor's boyfriend, Kenneth Walker, credible and totally believable. They said the police were not believable in those proceedings. Too many inconsistencies. That also is very, very damaging.
It's extremely damaging only for the Attorney General, Daniel Cameron, because what we're seeing is how a grand jury should not work. This is not the way grand juries work in any state, in any county, in any place in the United States of America. And what you're seeing is this gentleman bastardized this process in a way to ensure that a result that he wanted came out rather than actual justice.
This was a
Yep. Bravo across the board on all three of those there. When you have something like this that goes wrong, this is really concerning in the justice system. And here's why. Grand jury proceedings are supposed to be secret. They are secret. You really have no access to them as a criminal defendant. We are relying on the courts and the prosecutors to handle these things appropriately. Remember, when you go through a grand jury indictment, you don't get to go and sit there. If you're a defendant, you don't get to go walk in most situations and say, we're going to cross-examine that. So what happens is they impanel a grand jury of people, and then the government by themselves, they come in and they present evidence. So it's not like a trial, what you see on TV, where the defense is sitting right there and we get to object. Objection, that's hearsay, that's irrelevant. Asked and answered, or any of the objections. We can't do those because we're not there. We're not allowed in the room. So you're trusting that the Attorney General, the grand jury proceedings, the people who are actually a part of the process, you have to rely on them to do things correctly. Now, there are some checks and balances, so you can request transcripts after the proceedings have been completed, and you can write letters and submit letters that should be considered during the proceeding, and there's some technical things that you can do, but by and large, you're trusting that these things are being completed according to, ethical rules. Not only the Constitution, but as a prosecutor, you have a sworn oath to uphold and enforce the law. You're not supposed to go in there and carve out these little exceptions for your law enforcement officials. You're supposed to just, allow the grand jury to review the evidence and proceed accordingly. And what we're seeing here is an undermining of that process. If Daniel Cameron is now showing the public that the way that they conduct grand juries in his state under his leadership is so biased, it's so unethical, it's something where they are literally, breaking the rules on how this stuff is supposed to work, then why would anybody have any faith in any of the grand jury proceedings that are taking place under his watch? And that's a huge part of the criminal justice system. Thousands of people are indicted across this country every day, if not tens of thousands. A lot of indictments come out every day. And the reason why that process works is because we have some faith. We have some belief in there that the prosecutors who are in charge of bringing the evidence at least have some integrity, at least are following the ethical guidelines. Remember, prosecutors are not supposed to go seek convictions for defendants. They're not supposed to, just dismiss potential criminality for their officers or for their lackeys. They need to uphold the rule of law. They need to be for justice, not convictions, justice, which may mean dismissing cases and it may mean indicting officers. But Daniel Cameron, in my mind, was not somebody who was out there to do justice. This is a guy who's going to be running for higher office at some point in time. He'll be running for the Republican Party, and he'll go as a champion of the police, and he'll try to secure that segment of the demographics in his home state, and he'll probably be fairly successful with that tact. And so this was just, I think, a moment in time for him to mark a stake in the ground and say, this is how I'm going to define myself for the future. I'm going to be a pro-police, pro-law and order candidate, and I'm going to run in the mold of a Mitch McConnell or one of those people from that part of the country. Pretty concerning. Breonna Taylor's mom has come out and says that she wants Daniel Cameron to step down, said that the jury was flawed, the evidence was biased. She's asking for a do-over. So she wants a new independent prosecutor to be assigned, and they want a brand new grand jury proceeding to take place with the presentation of the actual evidence. We see here that a formal motion was filed. So Grassroots Law filed a legal brief demanding the appointment of a new special prosecutor in Breonna Taylor's case after Kentucky Attorney General Daniel Cameron failed to properly and ethically handle his case. And so it looks like this was filed by an attorney named Sadiqa Reynolds. She's the president CEO of the Louisville Urban League. She filed a pleading requesting that the office of the Prosecutor's Advisory Council appoint a special prosecutor, and we get a new grand jury in the Breonna Taylor case. So we'll see. We'll see what happens with that. It may be something that does actually happen, because I think from what we have gathered from a lot of these judges, they are also pretty disappointed with how this whole situation unfolded. We saw that one judge, who had originally agreed to keep these transcripts sort of under lock and seal, and had prevented the jurors from speaking out, actually, came out with a new order and said, yeah, go talk. Release the transcripts, let them go talk, because there was some irregularity, to put it mildly. So we'll see what happens. We will continue to follow along with Breonna Taylor, and we'll keep you updated as that story progresses. All right, moving on. We want to give an update on Matthew Dolloff. We'll call it Dolloff. Matthew Dolloff is this fellow right here. Remember him? So he was involved in a shooting that took place outside of Denver. He was arrested for shooting and killing a protester whose name was Lee Keltner. He was originally hired to protect local reporters, and he was contracted through 9 News. And this happened a few weeks ago. And this was one of those situations where people started to sort of part like the Red Sea and pick sides, right? A lot of the people on the left, a lot of the Antifa, BLM people were sort of rallying behind Matthew Dolloff because he had shot a very, vicious Trump reporter, a Trump supporter named Lee Keltner. So that was one side. On the other side, it was basically the inverse of that. It's a bunch of, Trump supporters and sort of people on the right wing side of the aisle saying that Dolloff was more analogous to somebody who is a part of Antifa. He's got a history of, being sort of vitriolic towards right-wing groups and right-wing organizations. And so, this turned into a political thing almost immediately, as these things tend to do. But it was an interesting case for a lot of other reasons. This was a situation where it happened very quickly, and I think it's a sort of an instructive case about self-defense. And we had some very interesting imagery that came out of this whole ordeal because it was just captured in such a unique way that it's going to be interesting to see what the court does with that evidence. And the court is actually taking a very hard look at the evidence, because very recently Matthew Dolloff had a bond that was set on looks like on October 19th. It was set at $500,000. Okay, so $500,000. He shot and killed somebody, and his bond is $500K. Now, what does that sound? That sounds a little bit low to me, right? If you're a regular on this channel, we've talked about a lot of the other bonds that were imposed. Specifically, the one I'm thinking of is Kyle Rittenhouse. Kyle Rittenhouse, a 17-year-old young man from Kenosha, Wisconsin. He's currently in Illinois. Well, his bond is set at $2 million. So why is it so much less for Matthew Dolloff? Interesting question, isn't that? But regardless, Matthew Dolloff was hired a defense team, and they went through and they wanted to reduce the bond so he could ultimately get out of custody. Remember, a bond is intended to secure a defendant's appearance. So if you shoot and kill somebody, the thought is if you're let out of custody, because the consequences are so high, you could go to jail, you could spend the rest of your life in prison, you could get the death penalty in some states. So the stakes are so high that if you have shot and killed somebody, the thought is you're not going to come back to court. You're going to flee to some non-extraditable country, and you're never going to be back. So what they're trying to do is make sure that they can do something to ensure you come back to court. And in many situations, that is setting a bond, posting up a lot of money. And if you don't come to court, you lose that money. Or you hire a bail bonds company, and if you lose contact with them, they send somebody to come find you and drag you back to court. So it's really for that purpose. And what they're trying to do now is modify that bond. So if it's currently at $500,000 and he can't get out, they want to lower that so that he can post some money and actually get out of custody. So we're going to talk about that. But because the judge mentioned some of the imagery in the opinion, I want to show you a couple of the images once again. So here is the photos that were sort of making the rounds across the internet, and people were basing a lot of their analysis on these two photos. And you can see here, this is Lee Keltner, and many people are saying that this is Matthew Dolloff. He's reaching into his inside of his jacket pocket. They're saying he was reaching for his gun. We have Lee Keltner making contact right here. So you can see here, I mean, there's just a million different arguments you can make from that one image. You could say Matthew Dolloff was being assaulted by Lee Keltner, and he drew his gun. He was acting in self-defense. And you could say that Lee Keltner was actually acting in self-defense because Matthew Dolloff was reaching for his gun, if there really was a gun there. I still have not seen that confirmed, but I've seen a lot of people speculating that that's what was going on. And so, this is when it started. We take a few frames next, and these photographs are being taken by a reporter who is literally running up and just in rapid fire succession taking photographs as they're approaching this altercation. Now, right here was this image that is just, I mean, it's perfect timing. You can literally see the shell casing coming out of the gun right there. So he had just pulled the trigger. The bullet is probably in the air somewhere. We don't even know where it's at, but the shell casing is coming right out just at the same point in time that Lee Keltner is actually spraying some pepper spray back towards Matthew Dolloff. And so you can see here that this altercation started, and then there's a big change in distance, right? From this first image, you can see Lee Keltner is sort of in line with this pillar right here in the fence. And then in the next frame, he's taking some major steps back, right? So he's actually retreating from this original altercation. And Matthew Dolloff is not so much doing that. Now, you could also argue that, it's just a different camera angle, because it certainly is. But we see here that Lee Keltner is sort of parallel with this bar in this image, and then he's not here. So he's taken a good, 3, 4, 5 feet step backwards and disengaging himself. Now, Matthew Dolloff over here really hasn't moved all that much. His stance is pretty much in the same spot, so he's not retreating. His response to this interaction is to just pull out his gun and shoot the guy. And so, people are on both sides of this thing. And we saw that this took place. We have a 60-year-old man who actually stepped in to try to break this thing up before it happened. There was a number of people who were involved in it, who were sort of concerned that this argument was going to evolve into an altercation. Of course it did. Perhaps this gentleman here, there were a lot of other people around, and we spent some time really dissecting that whole scene. So if you wanted to go back and watch the analysis of the frame by frame on that, please feel free to go do that. But that is a little bit of a refresher. Now, right after the shooting took place, Matthew Dolloff was, very compliant. He was on the ground. This is another image directly from after the shooting. So he just drops his gun, he falls to the ground. The judge wrote a ruling today and actually relied on these images, which is something that's a little bit unusual. And so I want to run through what that looked like. So here we have the order from the judge. It's from the district court for the city and the county of Denver, Colorado. This was filed literally yesterday at 4:02 p.m. This is the case number. It's in courtroom 4H. It's denying the request to reduce the amount of bond. So the court is saying here, this matter comes in front of the court and finds as follows. The bond was originally set at $500,000, but the defendant wants to review this. And they want to reduce and reconsider the amount of bond. But the people, the government here, is opposing the requested reduction. And the family of Lee Keltner's family is also opposing the reduction because there's a Victims' Rights Act. Anytime you're charged with a crime that involves a victim, many states have Victims' Rights Acts, and it confers a bunch of rights onto the victims, just like what it says. So in a situation like this, where it's potential that Matthew Dolloff gets released out of custody, they're going to bring the victims in and say, what do you think about this? You have a right to be heard on this issue. This person allegedly shot and killed your brother, loved one, spouse, whatever, and they want to get out of custody. What's your opinion on that? So the Keltner family, of course, is now opposing that. And so the judge then needs to consider what to do. The judge here in this case, his name is John Madden the Fourth, and he ruled essentially that a bond against Matthew Dolloff should remain at the $500,000. I'm going to go through his explanation here in a minute, but the defense came through and requested that they wanted to go down from $500,000 down to $25,000 and $50,000 just by arguing that he acted in self-defense. That's their basis for the request. And currently, he faces between 16 and 48 years if he's convicted of the second-degree murder charge. He's scheduled for a preliminary hearing on November 20th. So next month, he'll have that preliminary hearing. And so right now, basically all they're arguing about is, can this guy get out of custody? And this ruling from this judge is a little bit unusual. I'm going to explain why. We see here in the order where the judge is denying the bail, he says that the conditions of bond need to ensure the appearance of the defendant. They need to make sure he comes back to court. They need to make sure that the community is protected. And they also want to take into consideration the individual characteristics of the defendant. They're saying monetary bonds must be reasonable. They want to consider the level of the offense. They want to consider the risk and the circumstances of the defendant and a number of other things. So this is the rule portion of the court's opinion. They're laying out the rules. They go through it and they actually find a lot in favor of Matthew Dolloff. They say, look, he's got no prior events that are similar to this case. Shooting appears to be, a one-off situation, highly charged encounter. He lacks any criminal history. He would not pose a risk to anybody in the community. And it's looking like the only major issue here is whether he's going to show back up to court. He's not a crime. There's no indication that he's going to be a danger to the community. Those are the main things that you look for. You want to ask about flight risk. Is somebody just going to hop on a plane and go to, the Middle East and never return again? You want to, decide, if we let this person out, is he going to go do this again? Do they have a criminal history? Do they have a violent disposition? Is there anybody that they've immediately threatened? Is there anybody who's in fear for their safety immediately if we let this guy out of custody? And the judge came through and said, no, not really. Everything looks good. The only thing we're concerned about is whether he's going to come back or not. And what the judge did is actually sort of give us some hints as to how this judge feels about this particular case. And so I want to go through it because you don't often hear this sort of analysis this early in the case. It'll make more sense once I explain a little bit more about the order. So let's dive in. So the judge is going to be denying the bail. And here we see that the only valid rationale for a monetary condition is to basically make sure that he comes back to court, right? Again, we're going through this defendant's character. He's got no prior criminal history at all. And they start talking about the defense attorneys came in and they wanted to say that, he can go back to work. He grew up in Colorado. He's been there for the most of his life. He's got recently married. His family lives here. A lot of, letters were submitted talking about his character and so on and so forth. But then they said he can go back to work. Well, where's he going to go back to work? He can go be a security guard again. Right? He was being a security guard with 9 TV News, and now they're just saying, well, he can just go back and continue on being a security guard. The court says not so fast. They say that is not acceptable under the circumstances, and they also are indicating that the defendant has received death threats, and the family's keeping their location a secret, which, we don't condone any of that here at all. But it is important to his case. There's other types of employment where the defense would not appear to be feasible in light of the situation. Defendant does have family in the state, but they also have family out of state. So this is where the judge is going through the analysis about, is this guy going to leave or not? When at the defendant's residence, there's no landline, so they can't do any GPS monitoring. Oftentimes when they have home, sort of home detention, or they want to monitor you, they require a landline to be installed at your house. Many people don't have landlines anymore. I don't have a landline. I haven't had one in years, ever, actually. I've never had a landline in my whole life. My parents did, but I never did. And so, oftentimes you'll have to go and install one of those, and the family hasn't done that. Now, this is not a big deal. They can go get one installed anytime, but the court is noting that. The biggest issue that we see here is that the judge is talking about the likelihood of conviction, whether or not Matthew Dolloff is going to be convicted. And that is really the big element that the court is going to be hanging their opinion on. They're saying that it's pretty likely that this guy is going to get convicted, essentially. Let's see in here what they're saying. That the most significant factor increasing the risk of non-appearance is the potential sentence and the likelihood of conviction. So they're saying that, if you get sentenced on this thing, you're going to go away for a long time. And they also need to consider the likelihood of the conviction. So the judge is actually reviewing some of the evidence and detailing it. He says the defendant placed significant emphasis on the risk of conviction in arguing for a reduction. So they're saying it's unlikely that we're going to get convicted because of self-defense, right? They're saying a flight risk is not an issue because this is a self-defense case. And as soon as we go ahead and plead self-defense and we say this is going to be our defense, that I was acting in self-defense, that the likelihood that we're going to get convicted is so non-existent that there really is no flight risk. Therefore, you can reduce the bond down to $25,000 or $50,000. Well, the judge comes back and says, no, that's not what I'm seeing from the evidence at all. He says, as noted at the recent hearing, this is a unique case that the shooting was graphically documented in an exceptionally detailed manner. The interaction between the defendant and the victim and the shooting itself are captured by a series of clear, still-framed photographs separated by a fraction of seconds. The precision with which the moment of the charged homicide is captured is unprecedented in this court's experience. And the judge goes on and says, the defense counsel notes that the television news producer, who was the defendant, made a statement indicating that he believed the defendant had saved his life. Well, the after-fact statement appears to be inconsistent with the photographic images that document the event in detail. Wow. All right. So that may not sound that interesting, but it's pretty interesting because here the judge is sort of reviewing the evidence and then coming to a conclusion on the evidence, which is a little bit unusual this early in the case. Typically, judges aren't sort of making those determinations right now. They will analyze the other things like, whether a person's a flight risk, whether they've got prior convictions, whether there's any danger to any particular people in the community. They'll consider all of those things, but very, very rarely do you see a judge come out and say, yeah, I read your argument about self-defense, but I saw the photographs. That's not self-defense. Therefore, I'm more inclined to think that you will be convicted because your self-defense argument will fail, right? It's so early in the case, not a lot of evidence has been presented. And so for a judge to actually come out and detail that is a little bit unusual. Not entirely unusual, but a little bit, because we're sort of getting an insight into how this judge is thinking about the case. Now, the judge goes on, talks about, charging him with second-degree murder, first-degree murder instead. First-degree murder requires deliberation. It cannot be hasty or impulsive. So they're saying that the images here are not inconsistent. They appear to be inconsistent with self-defense, but they also appear to be inconsistent with first-degree murder. So the judge is sort of splitting it here, saying, I don't think this is self-defense, but I also don't think it's first-degree murder either. And therefore, the judge finally issues the ruling saying that they're not going to lower the bond. This is the last part of it. Not going to lower the bond because it's the likelihood of conviction is so high. But they will reconsider the ruling if there is new evidence, and they're not going to modify the bond. Right? So he's going to be staying in custody for some period of time, and unless he can post the bond, of course. Let's see here. We did have a question that came in from Fritzilla. Fritzilla sent a question in via email. If you want to send questions in via email, if they're relevant, we'll try to squeeze them in when we do these little recaps. But she actually had a question. I think it's a she. Fritzilla. Sounds like a she. She says that some people are saying that the picture of Matt pulling out his gun from his pants, there was a red-tipped item that looks like mace. If that's true, if he had mace, that would add to the idea that he did not need to use deadly force, but could have chosen to pull out and use the spray as a more reasonable use of force. And that's exactly right. When we were going through the statutes, we were actually looking at some of the self-defense statutes, and I want to see if I can find that. Let's see. Yeah, there is language in the statutes that says that you have to use the degree of force which you reasonably believe is necessary for that purpose. You can use the degree of force which you reasonably believe to be necessary for that purpose. So this is from section 18.1-704. You can use that deadly force or physical force, but you can only use the degree of force which you reasonably believe to be necessary for that purpose. So if Lee Keltner is firing off some mace and Matthew Dolloff also has some mace, you would think, okay, well, that's reasonable, right? One person uses mace, the other person uses mace. He pulls out mace, the other person pulls out a gun. That is not the reasonably the same use of force. You don't need a gun to end a mace attack. You just need to get away from the mace. If you have mace, you can respond in kind, but it's a little bit of a mismatch. So that question, I think, was a good one. And it is one that I think is reasonable. Now, I don't know whether or not he had mace. Maybe he did, maybe he didn't, but it sounds like the judge is leaning against self-defense anyways. The second part of that question was some different pictures from another angle and with contrast corrections show clearly that the victim had a gun under his coat, which I just mentioned. The news pictures were released, provided in succession, are darker and further away. They don't show the gun. It's hard to tell if Matt was truly reaching for the gun, as the picture suggests. Would have been an initial provocation that would force the victim to react. In this case, it looked like the victim did react by slapping Matt and then backing up. So that's Fritzella's viewpoint on that. She's also mentioning that they're missing frames, which I agree with. There were a lot of missing frames. We did play the sort of compilation of all the different images, but she says it's very clear considering how many images and how smoothly they work. Leading up to the shooting, there is a gap from time to time. He takes his gun out, grips with two hands, brings to bear, aiming at the victim's head. Where are those photos? That's the real controversy, if you ask me. And yeah, those photos seem to be missing. They may not have been taken, but if they were, then they are missing for sure. Last point, if he aimed his head and shot him, it's hard to reasonably think Matt expected anything but the death of the victim. So very good question. And thanks for sending those over, Fritzella. Hope that helped to clarify things. Where are the photos? I don't know. Maybe we'll see more of them. Maybe they're in discovery. Maybe they just haven't been leaked yet. Or maybe there are no photos, right? If that person was just going up there and snap, 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 snap. Oh my goodness, somebody just got shot. Snap, right? You're going to have a missing second or half second there. So we'll see what comes out. We have a super chat that just came in. Miss Faith notified me, says that Mr. Randy Mann with two N's says, I'm broke, have a buck. And he actually gave us two. So not just a buck, $2. Thank you, Randy Mann. Appreciate that super chat. All right. The last segment that I want to get into is about the Supreme Court. Very recently, actually today and yesterday, we have some new updates on what the Supreme Court is doing as it relates to the election. So the election is just a few days away next Tuesday. We're going to vote I am fingers crossed hoping that we have a decision on November 3rd. I don't know that we will, though, in large part as a result of these two cases. I want to share them with you. Supreme Court, as we know, has been the subject of a lot of controversy for this entire election. We had all of the Amy Coney Barrett confirmation. We had the whole debacle surrounding that with, trying to speed through the confirmation hearings, and now she's seated. She took her oath just a couple days ago, and now she is officially the 9th person on the United States Supreme Court. But it's still so new that she didn't take part in either of these rulings. So we are missing a full court on these rulings. And it's also interesting to note that Judge Kavanaugh, who's also on the right side of the court, was also missing from these court proceedings. So what does that mean? It means that we had a little bit of a left-leaning court as it relates to these two decisions. So let's take a look at what happened. The first case is coming out of North Carolina. Now, North Carolina is technically on our list of battleground states. We have a list, I think, of 8 of them, which we'll bring you up to speed on. But this is one that a lot of people are eyeballing in large part because of the issue that takes place. So this case comes from Timothy Moore versus the State Board of Elections out of North Carolina. This is the actual Supreme Court heading. This is the opinion. And you can see here that there's not a lot of information. The full opinion is only 3 pages. I'm not going to read through it. I'm just going to give you the highlights on it. But I want you to see here that this came out literally yesterday. The application was presented to the court, to the Chief Justice, and it was denied. So what are we talking about? We're talking about a case that was working its way up to the Supreme Court, and they were asking the Supreme Court to hear the case and to do something about it. And the Supreme Court said, no, we're not going to hear it. So get out of here. Justice Barrett did not take any part in the consideration. And we have the 3 conservative judges who did join and write an opinion saying that they would have granted the application. So it was denied, but these 3 gentlemen would have granted it or at least heard it. Justice Thomas, Justice Gorsuch, and Justice Alito joined in dissenting from the denial. So they want to have this story heard. Now, what is this case about? Well, in North Carolina, here's what happened. So the Northern Carolina Alliance for Retired Americans, they challenged a law. North Carolina had a law in place that said all mail-in ballots need to be received by November 6th. Okay, so the election takes place on November 3rd. The rule in North Carolina was all the ballots have to be in our possession by the 6th, 3 days after the election. So basically what they're giving you is a little bit of leeway. If you wake up and you go, oh, the election's today, I got to get my ballot in, and you write your ballot out and you throw it in the mail and they get it 3 days later, they're going to count it, even though the election's over. That was the original rule. Coronavirus, of course, wrecks everything, and it gives people a lot of opportunities to maybe change those rules to something that is a little bit more their liking. So what happened was that Northern American Alliance for Retired Americans, they filed a lawsuit, and they were joined by some other, concerned citizens and other interested parties. They brought this lawsuit, and they specifically sued the Board of Elections in North Carolina. Well, what ended up happening is North Carolina and these plaintiffs, the people who filed the lawsuit, they came to what's called a consent agreement. So they reached an agreement. Now, remember, the original law that was written into law by the legislature, by Congress in the state of North Carolina said 3 days. That's what they said. Well, the lawsuit came through, they filed it, and they met with the county elections, the Board of Elections for the states, and they decided that they were going to make an agreement that was different than the law. The law said 3 days. They didn't like that. They filed a lawsuit, and they started negotiating. So they come to this agreement that says, okay, instead of 3 days of the extension, we actually want 9. And they entered that agreement. So now you have 9 days now to mail your ballot. So you can literally have the election on November 3rd. You can wait, 5 days and say, you know what? I forgot to return my ballot in, and it looks like my candidate is losing. So maybe what I'll do is I'll actually go dig my ballot out, the one that I was so negligent about getting in on time. Now, because I see what's happened, my candidate, if he only has 1,000 more votes, maybe he's going to win our state. So I'm going to go dig my ballot up, and I'm going to go get it. And I'm going to go drive it into the mailbox or, throw it in the mail. Well, North Carolina is saying, sure, that's no problem. If it takes 2 days to get to us, all you can throw it in 7 days after November 3rd. We don't care. It's fine. No problem. Throw it in. As long as it gets to us within those 9 days, we are going to count it. Okay, so again, this is not a law that was passed by the legislature. This is not a law that the people voted on. This is a law that somebody who filed a lawsuit started, and the county elections or the state elections person made this agreement. Yeah, 3 days is not long enough. So because of coronavirus, let's make it 9. How's 9 sound? 9 sounds good. They entered that. Well, Republicans said, no, you can't just change the rules at the last minute. And they submitted this stuff to the Supreme Court. Now, their argument was they're interfering with the elections. They're interfering with the legislature. The law is what it is. It said 3 days. We should stick to 3 days. And you can't just change the law haphazardly whenever you want. The Democrats came back and said, wait a minute, we've already reached a consent agreement. We've already made an agreement. And now if the Supreme Court starts to modify that or reject that, it's going to cause even more confusion with the state. People are not going to know. People have already been told they have 9 days. So if you come back and say, no, it's 3 again, then you're going to have a lot of people who are just sort of caught in that gap. They're not sending their ballots. They didn't hear the update to the rules. So the Democrats are saying, no, we need to keep it at 9 days. And what ended up happening is we had a result where they are going to keep it. And here's what it looks like. So this is what a full court looks like, right? This is everybody who's on. Barrett came in and replaced Justice Ginsburg. And so this is the 6-3 court that we are seeing traditionally now. Now, this is the standard court. This is the full bench, at least until the Democrats decide they want to modify the entire judiciary by packing the court. So that's what it looks like. And many people are up in arms over this and saying, oh my gosh, this is a conservative tyranny. The whole court is just going to ruin the American way of life. The liberal wing of the court is never going to win ever again. Life is over. The sky is falling. What are we going to do about it? Well, that's not really true. I mean, we see here that that's not really how it played out. So this is what the ruling looked like that we just were reading from. We see that Amy Coney Barrett was not a part of this ruling. She didn't recuse herself, but her rationale for not being a part of this opinion was that she just didn't have time to read the briefs. She just got seated. She's not familiar with the case, doesn't feel comfortable making a ruling on it, which in my mind is very, very weak. Actually, one of the first disappointing things I told you, I was just ready to be hurt by Amy Coney Barrett, and she's already starting that. This is an important issue, and she just bailed on it. But whatever it is, that's her position on it. Now, Kavanaugh, I don't know why he didn't participate in any of these opinions, but we have Justice Roberts, who is supposedly a conservative, joining the liberals. And in large part, the reason for that is he doesn't like to meddle with the lower courts as it relates to election issues. That's just what it is. So if he joins with the liberals, that means the lower court standing the opinions are going to stand. They're going to carry over, and nothing is going to change. So we see, it's a pretty simple 3-4 split. The liberals take it, and what that does is it actually modifies the category that we had for North Carolina. So when we were previously analyzing the battleground states and how they were going to fall, which campaign they were going to support or help, this is what it looked like. We had, Arizona was going to Trump according to the rules. This is the law. This is our analysis of the legal findings of the lawsuits that are taking place. And you can see here in North Carolina, the last time we talked about this, we put this in the Trump camp. And today, that's not so much the case. The appeal was pending in the Fourth Circuit. The district court did deny the modifications, and the consent agreement was pending. But now today, we know that this has flipped. So it went from Trump over to Joe Biden. The Supreme Court, in a 4-3 opinion, they refused to overrule the extension, and the ballots can be received up to 9 days after the election. And that's because Judge Roberts joined in on the left. So North Carolina flips over to Biden. They can now collect ballots for up to 9 days after the election. So if North Carolina is close, that's going to be one to watch for a very long period of time. Literally 9 days after the election. Over a week later, ballots can still be counted, which is, I guess, that's one way to run your state elections, I suppose. All right, so the next case that we wanted to talk about involves a very, very highly contested state. This is the last one. We're going to get into the live chat here in a minute. This is the last one. This comes from the Republican Party of Pennsylvania versus Kathy Boockvar. Again, this is along the same lines. You can see here that the motion to expedite the consideration for the petition for the writ of certiorari, this is basically they're applying to the Supreme Court again and they are basically denying this. So the statement of Justice Alito, again, Justice Barrett took no position on this, but they're not accepting any rulings for this. We've got Justice Alito, Justice Thomas, and Justice Gorsuch, who are all dissenting. So again, this was the full court. This is what it looks like after the court, right? So Alito, Gorsuch, and Thomas are all dissenting on this one. And what they're talking about here is it's a very, very similar issue, in fact. And it says, this is from the opinion itself. Let me give you the highlights before I show you the text. In Pennsylvania, like everywhere, right, we're all sort of battling the coronavirus stuff. So what they did is they passed an act before the coronavirus called Act 77. Act 77. It sounds like Order 66, right? One of those. Okay, Act 77. It was passed in 2019. So this is all pre-coronavirus stuff. And it passed the legislature again. So the state legislature, not the governor, not the judges, they passed the law. And the law said all voters can mail in ballots. This happened in 2019. Everybody can mail a ballot, as long as we get it by 8 p.m. on election night. So mail in, no problem. They made that change. As long as the election county recorder gets it by 8 p.m., it's fair game. And they specified in that law, in writing, that if that deadline is changed, then it's very likely going to invalidate the rest of the mail-in ballot law. So that's a hard deadline. The legislature put that in place. Okay. Well, in March 2020, right after we had the ban from the coronavirus was, just rampaging through the world and through the country, we had the travel ban and we had all of the lockdowns start to go into play. So in March 2020, after the pandemic started, in Pennsylvania, they passed a new law to address the election. Okay, we're going to modify a bunch of stuff. Well, they didn't change the deadline. So they kept the deadline the same on the night of the election at 8 p.m. So the legislature passed it in 2019. Then they came again in 2020 in March and said, we're going to revisit this stuff and we're going to not change the deadline. So we've got 2 times now where the legislature is on record to keep it on the deadline on November 3rd. All right. So again, we have some new lawsuits that get filed, and they want to modify all the election rules because of the coronavirus. Well, what ended up happening is these lawsuits went up to the state Supreme Court in Pennsylvania, and in a 4-3 ruling, the Pennsylvania Supreme Court changed the law. So the legislature wrote the law. They set the deadline. The state Supreme Court changed it. It didn't go back to the legislature. They just modified it. They said that ballots are timely if they are postmarked on or before Election Day and received within 3 days afterwards. So that was not in the original law. That was something that the court created in their rulings that now is the law. Okay, so this is the big problem between originalists and non-originalists. An originalist says the law said 8 p.m. on Election Day. That's what the law is. The legislature could have changed it. They can change it now if they want to. But a judge should not be able to read literally a statute in Act 77 and in the follow-up act in March, and the judge can read it and say, okay, I know that's what the law says, but we don't like that. So we're just going to go ahead and modify that. Okay, that's called active liberty. That's called, modifying things in order to come to what the court believes is a just outcome. But who's to say that's just? And the problem with that is that a lot of different judges can have a lot of different opinions on how this stuff should unfold. So the state Supreme Court came in, voted 4-3. They said ballots are timely if postmarked on or before Election Day and received within 3 days afterwards. Now, in the opinion itself, the Justice Alito comes out and he says that the Court of Pennsylvania issued a decree that squarely alters an important statutory provision that was already enacted by the legislature. So the court changed the statutory provision. You're not allowed to do that, right? The court is supposed to interpret, not to just suddenly change and alter things. And he goes on, he says, in the face of Act 77's deadline, the Supreme Court, by a political vote of 4-3, decreed that the mail-in ballots don't even need to come in by Election Day. If they created a different rule, they're to be treated as timely if they are postmarked on or before Election Day and are received within 3 days, therefore. Okay. In addition, the court ordered that a ballot with no postmark or illegible postmark must be regarded as timely if it is received by the same date. So you don't even technically have to mail it. You can actually submit a ballot after Election Day, as long as it's not postmarked and they don't, and the people who are counting it don't see a postmark, they can still count it, even though it technically came in after the Election Day. There's no enforcement mechanism there at all. And the court order specifically says, if it's illegible, if there is no postmark, which often happens, okay, right? Your ballot, which I sent mine in, if you look at it, it says no postage necessary. And on a lot of those things, you probably have gotten them in the mail. The ones that come through with no postage necessary, they often don't get run through the mail stamping machines that actually puts the postmark on them. So you can actually, you can have a lot of additional ballots if, let's say Donald Trump wins Pennsylvania by 10,000 votes. Well, the day after the election, theoretically, the parties, both parties, the Republicans and the Democrats, can race out there, go, secure as many ballots as they can, and Donald Trump's team can want to increase the lead, and the Democrats can try to make up that lead. And as long as those ballots are received by the county, and there's no way for them to distinguish between whether or not they were actually sent after the election or before, because there is no postmark, and the lack of a postmark is this escape valve for the court. So they can all come in and they can all be counted because the court just decided so. The legislature didn't do it. The people didn't do it. Nobody voted on this issue. It was a 4-3 election year decision. It's a political decision. Of course it is. And the only thing that they're doing to mitigate it, now the Supreme Court heard it. They said, yeah, we're not going to meddle. We're not going to get involved in this. We are not going to even play around with this. The court noted that the statute was clear. So they said that they changed it anyway. So the court who actually wrote the 4-3 ruling, they said, we know what the deadline is, but we're changing it anyways because it's not fair. And they said, this is a natural disaster. So even though it says 8 p.m. on election night, we're going to change it because we're in the middle of a natural disaster. Well, what authority do they have to just go in and change statutes that they want to change? They really don't have any. But because they have the majority, they have a 4-3 majority, they're going to get away with it. And this went up into the Supreme Court, and the Supreme Court just turned around and said, yeah, we're not going to rule on that issue. So you guys just keep on doing what you're doing. The federal Constitution gives the state legislatures, not the state courts, the ability to run the elections. So Justice Alito was actually going through this saying, what this court is doing is totally unconstitutional, actually. It's a separation of powers problem. The court doesn't get to act as a legislature just because they're in the middle of a natural disaster. It's not how it works. The courts don't get to do that. We have a separation of powers. We have checks and balances. It would be like Donald Trump going, walking right over into the legislature and just saying, yeah, we're going to change all those rules. I don't like them. It's basically the same thing. That's not his role. He's an executive. He doesn't have authority to do that. That's why I have a lot of problems when the executive starts stepping outside of its hula hoop. You have your limited rules, all these executive orders and these government agencies by fiat and all this stuff. It's not really how the system is supposed to work. We're supposed to, each different branch is supposed to secure, is supposed to fight for their own authority, and each other co-equal branch is supposed to push back on the branches that are intruding into their affairs. In this case, the judiciary is clearly intruding on the affairs of the legislature, and they're doing it under the guise of the coronavirus. Everything's about the coronavirus. Everything needs to change because the coronavirus is wiping out the country or whatever, whatever they want to concoct about that. Now, there was a little bit of a modification going on here. They are going to be segregating the ballots that are received between between 8 p.m. November 3rd and 5 p.m. November 6th. So they are going to then, actually, if stuff does come in after the fact, they're going to segregate those and hold those separately so that we can see what they look like. I'm very curious to see how this goes and exactly how many of those are not postmarked. And if they're not postmarked, where did they come from? Are people just going to be showing up with vans of ballots down at the county elections office or the state election office? What are they going to do if that happens? Are they just going to say, how are they going to argue it? There's no criteria to have that conversation. What if somebody else comes and says, yeah, look, I had all these ballots. They were, I collected them, or I found them, or I did something with them. They were all drafted on November 3rd and there's no postmark, how do you prove it? What's the court going to do? Are they just going to throw all those ballots out? Everybody on both sides of the aisle is going to cry foul. Everybody. Unless Pennsylvania is a blowout, unless, one of the two candidates runs away with it, it is going to be a mess, especially because there's 3 additional days and Pennsylvania is so hotly contested. It's one of the biggest sort of battleground states in my reading of the field. Now, this is what the final sort of outcome looks like as of today. So we can see Pennsylvania really didn't change much. It was already going for Biden, and it's going to be sticking with Biden. And, it's looking a little bit more even today. Previously, we had North Carolina, which was in favor of Trump, but there are still some other stuff that are pending. And so we will continue to update this when we know more about what is going to be happening on the elections. All right. So that is it for the content of the program. Now let's jump on over to the live chat, see what kind of questions we've got going on here. As a quick reminder, Miss Faith is in that room right there behind me. She helps me prep the show and she helps me with the live chat. So it's always good to get warmed up by saying, hello, Miss Faith. And we'll see what some of the questions are as I open this up. So we'll get those keyboards warmed up. Let's see. Let's see what some questions we've got. We've got James High. He says, Trump can't be a dictator. None of his accusers have died mysteriously, have they? That's a good question. I don't know. So I think that's sort of going off of the meme of the Hillary, right? Basically everybody dies if they're related to the Clintons. We have a van of ballots. Seriously, 8.8% of the population dies every year in the United States. The current U.S. population is 376 million people. Comes from Mule 83. J.E. Bennett says less than 3% of gun murder is done by an assault rifle, which I think is right. I think handguns are by far the most common most common firearm that results in actual deaths. We've got Glenn Jones, who says, sounds like we need a French treatment of judges. We have FC Drifter, who says throwing away votes is anti-American. What do you consider an assault rifle? That's a good question. I don't know what the technical definition is. Probably a semi-automatic rifle that is of a certain caliber. I don't know what the official definition is. I would say that I own one. That's for sure. Let's see. Mule 83, to be honest, more people die by hammers than by weapons. Zorro's here. He says, with 330 million people, having only 10 or so police shootings a year is a very small number. J.E. Bennett says, I consider an assault rifle an automatic that Joe says is scary and black. We have Luke M., who says, hello, Miss Faith. Zach Wallace is here. He says, at R&R Law Group, the Senate Committee on Homeland Security has verified the evidence provided by Bob Ulinsky. Also, the Flynn documents have been properly resubmitted by the DOJ. Sullivan can't ignore. What do you think? Yeah, so the Bob Ulinsky stuff is still heating up. We are taking a little bit of a break from the Bob Ulinsky stuff today, just because I want to take a break from it. Quite frankly, it's been this constant drip of things, and I know stuff is leaking out. I think Tucker has a follow-up release scheduled tonight, so we're going to continue to follow it. I think there's, as I've talked about ad nauseum on this channel, there is a lot of I think reliable and authentic evidence there. We now have a guy who was an ex armed services individual with the Navy. Family has a history in the armed services. He was the CEO of a major company that Hunter was specifically doing business with. We've got a lot of emails that are documenting all of this stuff. We've got his personal knowledge. We went through the federal rules of evidence talking about what constitutes personal knowledge. Tony Bobulinski 100% hits that. He complies with the federal rules of evidence. He would be able to come in and testify at any criminal trial, regardless of what type of case. He is allowed to come and talk about it. We talked about relevancy, whether or not what he is saying is relevant to a potential crime, or even just to the potential conversation of whether or not you're going to vote for Joe Biden. If we just use those rules, we can see it's all very relevant. So the media not doing anything about it is mind blowing. I wanted to show you this website here, this ground. Well, no, what is it? Let me see here. Let me see if I can find this while I've got you, because it was, it is interesting. So here is the article. So here is what we're seeing about this Hunter Biden stuff. I don't know if you've seen this website yet. This one's pretty interesting. I don't I don't spend a lot of time on it other than with this story, but here's what you can see. Ground News, what they do is they want to show you what different news websites are covering the story. So here you have, this is the Hunter Biden story. You've got all of these news agencies, these right-wing news agencies are covering it, but almost nobody in the center and nobody on the left is even talking about it. Just a total whitewash of the story. And it's just pretty wild. There are one duplicate articles sourcing the Gateway Pundit. It's got a 5% left bias. This news story is a blind spot for people on the left. Nobody even knows about it. Fox News, right bias. So you can just see it here. They're not talking about it. It's totally being censored, and it is kind of mind-blowing, quite frankly. So the General Flynn stuff, I haven't taken a deep dive into that, but it is one that we kind of missed the General Flynn stuff. That story started a long time ago, and so I haven't done a deep dive to get back into it, quite frankly. We got McLovin, who says, hey, Rob, I just lost that. Let's see if I can find that again. McLovin, hey, Rob, after the documents proving Joe's involvements were lost, are you ready to condemn this obvious smear campaign against Biden? Or at the very least, call it what it was, a misinformation agenda? So it's a great question. McLovin's here a lot and obviously doesn't like the take that we have been covering here, which is totally fine. McLovin, I appreciate you being here. First of all, I think the documents were found. So Tucker Carlson said that they were lost, made copies of them. And then I just saw on Twitter that UPS said that the documents have actually come back up. They found them. So they were able to track them down. And we'll see. We'll see what those documents show. Now, I completely agree that this is an election year October surprise story. There's no question about it, right? This is intended to hurt Joe Biden. There's no question about it. And I don't even know why anybody would think otherwise. If Rudy Giuliani or Donald Trump or any of these people come out and say, no, this is just coincidental timing, give me a break. This is 100% crafted and it's been sat on and they want to use it as a campaign tool. No question about that. I would totally agree with that. Now, is it a smear campaign? I don't know about that because a lot of the evidence does seem to have some weight to it, right? We've seen this consistent drip of information that's being leaked from Hunter Biden's hard drive, from his laptop. We've got emails that have been confirmed. We have Hunter's former business partner who's in prison, who gave people access to his account. We've got numerous different sources who are all starting to authenticate this stuff. And I don't know how you say that's a smear. It certainly sounds like there is enough there to at least start asking the questions. And I think asking the questions is perfectly reasonable. I don't see how that's a smear campaign. It's just us reviewing the facts. Joe Biden is, if you believe the polls, going to be the next president. And if his son is going to be in a very close proximity to him and also engaging in a lot of these, suspicious dealings throughout the world, we need to know about it. And I think it's reasonable to talk about it. And the fact that the mainstream media, some of these center left people are not, is the big reason why I've been talking about it. If they would, I think it's even worse than the content itself. I think it's worse that they're trying to literally craft our version of the news or the version of the information we received in order to impact the election. That's more offensive to me than the underlying material itself. Good question, though, and I appreciate you being here, McLovin. Thanks for that. All right, we have another question from Rudy Rhodes, who says, hey, Faith, my question is, can judges be held accountable for creating new laws by avoiding statutes, as previously said, or do they have qualified immunity like the police? So, yeah, judges have a lot of autonomy to interpret things the way they want to interpret them, right? We give them that power, we give them that authority, and there's a huge part of the judiciary, there's a huge part of the legal world that thinks that is perfectly okay. Okay, the liberal justices, Ginsburg, Sotomayor, Kagan, Breyer, all of them are of this mindset, of this active liberty mindset. So they want to interpret the facts and interpret the law in a way that creates what they perceive to be justice. And they don't have to necessarily rely on the statutory interpretation. This is why I am more of an originalist. I am more of a textualist. I think that if you give judges the discretion to do whatever they want with the statute, you're going to have a bunch of activist judges who are doing whatever they want. And so we want more judges to be more in alignment with the originalist line of thought, where they're just interpreting the text. They're just reading the statute and they're making their analysis based on what the language of the law is. They're not just introducing new things. They're not saying, okay, I just read the law. We know that the people who elected the legislatures who passed the law, we know that they wanted the deadline to be at 8 p.m. on election night, but we don't like that, so we're just going to extend it to whatever the hell we want. That type of discretion is not what the judiciary is for. If those judges want to go and modify the law, then they should go run for Congress. They should go run for the state Senate or for the House of Representatives or whatever. So that's the appropriate forum to do these things. They can't do it after the fact on an ad hoc basis, just based on whatever they want to find. Now, are there any repercussions for them? Not really. They're elected judges, and it is a legitimate judicial philosophy. You can do those things, as we're seeing is evident by the Supreme Court, right? They're just saying, yeah, that's a reasonable interpretation. We're not going to meddle with that so close to the election. So the answer is yes, they have qualified immunity. They're not going to be liable to a lawsuit. They're not going to be charged with a crime for exercising what they consider to be a reasonable judicial philosophy in the exercise of their duties. All right. If ALWLLMS says, if Hunter broke the law, wouldn't Tony also break the law since he was the CEO? Yeah, and we had a long discussion about that yesterday, the idea that they were, I think that actually lends credibility to Tony Bobulinski. If he was out there, saying things that might actually hurt him personally, it's much more likely that those statements are credible, because why would anybody go out there and make up a lie that could ultimately come back and bite them in the butt? They wouldn't. And we've talked about this, as well, that in criminal law in general, when somebody is making admissions, when somebody's telling you something that they were involved in, you give those statements a lot more credibility. So that's another reason why I think Tony Bobulinski's statements are reasonable. Okay, we have one from FC Drifter, says, Trump gave the ATF the power to redefine weapons and accessories. So now they are. We got a lot of gun talk today. We have John Perryman, who says, Dolloff was standing his ground, looking at the ground markings. You can clearly see the guy with the mace move back 4 or 5 steps. He did not fire the mace until Dolloff pulled his gun. Yeah, I mean, that's how I viewed it as well, John. And I think that's a good analysis. We went through the video, or the actual still frames today, and you can see that, right? At one point, he's in close alignment with one of the pillars in the fence in the background. And then you can see, once Matthew Dolloff's gun is drawn, Lee Keltner was actually 4, 5, 6 feet back. He was disengaging and he got shot. So I think that was what really makes it not self-defense. He was backing up. I don't think that the bullet needed to be fired, and it was. And so now he's going to be charged with murder. I think it's probably not a very defensible case. Mac Bolin says, I too love the law. Biden is in deep S. So is Daddy. Don't mess with Rudy. We've got Carl Sillytoe, who says, I like Sweden and the way it handled the virus, showing us all how we can retain freedoms even in a health crisis. I support Trump in keeping his campaign promises. Yeah, Sweden was an interesting experiment, and I think we're still sort of in the middle of this coronavirus thing. I think there's still a lot of game left to play on this before we'll be able to make any conclusive judgments about whether one country was good or not. We have Obina IBE, who says, wonderful show tonight. Thank you, Obina. Appreciate you being here. The Nito God says, I agree with Ted Cruz. The Hunter Biden story will not change a single mind, and that the Trump campaign needs to focus on something else. Interesting take on that. Yeah, I'm not sure how many minds it's going to take. I think in large part because it's just being totally silenced on the left side. I mean, there's a lot of people in this country who have no idea who Tony Bobulinski is, or even know about Hunter Biden's hard drive. All right, we went through this yesterday. Miss Faith did an awesome job pulling up some clips of, searching for Tony Bobulinski on the New York Times and on NPR, and you can't find it. It's a total media blackout, even though it's credible enough to be discussed. Whether you think it's indicative of a crime or whether this is something that should disqualify Joe Biden, that's a different question. Totally different question. But is it relevant enough for the news media to report on it? Is it relevant enough for the average American voter to know about it? In my mind, absolutely. Absolutely, yes. Luke M says, do you think if Biden wins and the Dems pack the courts, our gun rights will be in jeopardy? Of course. Of course. I think that amongst many other rights will be in jeopardy. If they pack the court and they control the Senate, so they have to control the Senate in order to do that. If they control the presidency and the Senate and the House and the courts, I think you are going to see a just cascade of major modifications that I can't imagine that many of us will be too happy with. We have Mac Bolin, who says, we have a clear case of the money laundering directly involving the chairman, Joe Biden. He's getting impeached, guaranteed. We have Zorro, who says, I heard 16 million tuned in to Tucker's interview with him. Yeah, that's a lot of people. The last I heard, it was like 7 million, but I'm sure that's probably just the cable news. In addition to that, it's probably, many, many more millions of people who watched it online like I did. I don't even have cable. McLovin says, they said Obama was coming for our guns too. Zulu's here. He says, hi, Faith. We got Mike James, who says it took 3.5 year long media political celebrity ambush to get Trump out of office. Yeah, he's been under an assault for a very, very long time. No question about that. We have... how much would you spend on defense trial if it was you, Rob? That comes from MN Let's Go Trump 2020. How much would you spend on a defense trial if it was you, Rob? I guess it depends. If I was being charged with a crime, it would depend on the nature of the crime. If it was something where I was in Matthew Dolloff's situation and I was facing 16 to 48 years or life in jail, I would liquidate every single thing I owned and try to raise up, as much money as I can for my defense. But if you just get a traffic ticket, you don't need to go all that hard on that, I don't think. All right. We have JD says if Biden wins, he won't be in office long. He won't be in office long enough to get impeached. We got Mac Bolin says, I've read the emails and instant messages myself. Junior gave up every one. Beautiful One says, McLovin, the FBI have 26,000 emails from Hunter's laptop. Tucker's hard drive is different material. Bill Given says, hi, Rob and Faith. Do you think the media outlets like Google and Twitter will change anytime soon based on having to testify in front of the Senate? Yeah, we spent a lot of time yesterday talking about 230, and I think that is a good question, and I think the answer is no. I think there's no reason for them to change. I think you're going to hear a lot of the superficial, sugarcoating talk like, oh, we need more transparency. We need more... we want to show you how the algorithms work, and we want to give you access to control more of your data. And we need to be better. We hear that all the time. We need to do better. We recognize that we didn't respond to that well. Okay, well, it only matters really right now, right? If they censor a Hunter Biden expose on January 1st, it doesn't matter because the election's already over. So they know what they're doing. They know that they're acting with the ability to influence the election. That's why they're doing it right now. They know that they're going to have to apologize for it. But by the time they do, the issue is going to be moved on. It's going to be over. So the impact they're having is now, and they're going to pay for the repercussions later down the road. Is that going to change? I really don't think so, unfortunately. Unless something does happen with Section 230, which I do not think that it will. Because remember, a lot of these senators and politicians are supported by the tech companies just through and through. They give them a lot of money. All right, we have a message that Miss Faith sent over from Kevin Sharp. Says, hey, Faith, what other ways can Trump get the Hunter story out to Democrat voters since CNN and the rest are blocking the story? Well, one of the things I would suggest, of course, is that you share the content that we've created right here on this channel, right? We spent a lot of time on the Hunter Biden stuff. A lot of people, colleagues of mine, out in the legal world and elsewhere saying, Rob, you're better than this. You're better than this. How could you talk about this? You should be ashamed of yourself. I've known you for a long time. You're alienating people by covering this story. All right, that's fine. I still need to talk about it, right? I need to talk about it because I think it is super important, and I think that the ball has been dropped by a lot of the people who are responsible for bringing us information. They're just ignoring the story completely. So I would love if you shared our channel. But in addition to that, maybe just ask a question. Hey, have you heard about Tony Bobulinski? Did you hear about that? Or another suggestion I've heard is that you actually reframe the story as though Donald Trump Jr. did it. Hey, did you hear about Donald Trump Jr.'s hard drive? Yeah, man. He's got all these, really grotesque, like pornographic pictures on there and There's all this evidence that he's engaging in these deals with China. Isn't that crazy? And people will say, yeah, that's horrendous. I know Trump's a dictator and he's basically a Nazi. And you say, well, that involved Hunter Biden, not Donald Trump Jr. See how that works. Quite frankly, I'm not sure that it's even worth it in my mind. You know, a lot of these people, they're not changing their opinion one way or the other. But I would encourage you to share it. I'd encourage you to speak up a little bit. You know, you are going to get some flack on these issues. There's no question about it. I get a lot of it. And it's just part of the deal. You know, Mercury is in retrograde right now. I'm not a big, astrology person, but I do think there's something to it with these planets swirling around. Mercury is in retrograde, and my understanding is that the retrograde is actually over on November 3rd or right around there, which is a weird coincidence. So look that up. But my point is, when you're talking about these issues with people, you're going to get a lot of feedback. You're going to get a lot of flack, and you just have to ask yourself, is it even worth it? Is it worth engaging with these people? In a lot of my days, I think that it's just not, right? We got a super chat from Michelle in Bergia. She says, thank you for covering this. Thank you, Michelle, for that. Really appreciate you being here. You know, I do appreciate that people also are interested in these conversations, because it is, I know it is tense. I know it is heated. The volume is super high right now across the board, and it's only going to continue to be that way. I've gotten messages from some people who I thought had it all together, and then they send me something and I'm like, all right, that person is hot. That person is really sort of, wobbling a little bit. And so have some empathy. Certainly don't gloat about any of this stuff. I've tried my best on this channel to not be slam dunking Hunter Biden every day. Oh yeah, more pictures. Oh yeah, more malfeasance. Trying not to do that. He is, I think, a broken man. He's a human being. He's got a family. He's got children, and we don't want to be callous in our dealing with other human beings. So, keep that in mind if you are going to be spreading the news. We want this to be something where we're good representatives of humanity. That's what I would encourage. Okay, Beautiful One says, I'm off here. What's all this muddying the waters? Most people have made up their minds. Democrats are worth my time. They are worth my time. They are intolerant and think they are gods. That's from Beautiful One. We have J.E. Bennett, who says, truth is always stranger than fiction. Social Crusader says, incredibly important. Hunter is compromised and a liability. Raven Tempest says the justices ruled against the first case because they disagreed and refused involvement in the second case because, and then we in there. We got MN Let's Go Trump 2020 says, I tell people I don't vote and it ends the conversation. People slam Trump all the time. It's payback to the Bidens. Somebody's doing leaving a double up, leave a thumbs up. We'd appreciate that. What else do we have? They're already starting to switch to the lame duck argument because they know Biden is losing badly. Do you think Trump should fire Wray before the election? That comes from Michelle in Brugia. Oh, that is a tricky question. That is a tricky political question. Probably not. It's probably a little bit too volatile for that. And I don't know what that would serve other than to just rile everybody up. If he fires Christopher Wray and he installs somebody else, is there enough time for the FBI to do anything? Right? They've been sitting on this laptop allegedly since 2019 when they originally issued the subpoena from the district court to go in and seize the laptop from the Mac store repair owner. So if they swapped out the leadership at the FBI and they put somebody else in there, by the time that all happens and that transition takes place, I think we're already at Tuesday. So the only real tactical advantage would be if Donald Trump got rid of Christopher Wray, brought in somebody else who actually was interested in pursuing the investigation into the laptop. Then at that point, they could release something or put together a public statement, something that would be consequential to the election. If that were the case, then maybe that would be a wise tactical decision. But without that and without, with very limited time left, I'm not sure what it would do other than to rile up people. And it would probably give more credence to the argument that Donald Trump is this dictator and that he wants to, go against our, national security agencies and all this stuff. So I don't know that the pros outweigh the cons, but it is an interesting question. I know he has indicated that he's going to be doing that after the election, probably whether he wins or not, right? He's still going to be in office for a certain period of time, and he'll have the ability to do that. We have J.E. Bennett who says, good job, R&R. Thank you. Thank you, J.E. Bennett. Appreciate you being here. I see your name a lot. Appreciate you chiming in on the channel every day. McLovin's here also. He says 85 million votes are in. Paul Fun is back. Says Barr will be charged with obstruction of justice. I can't wait. That's interesting. J.E. Bennett says, yeah, Trump is going to clean house in January. You know, that's one of the most interesting things about a second Donald Trump term. Is he going to be even more Trump, right? He's doesn't have to run for re-election again. So, you know, a lot of me was thinking maybe this is when Trump is really going to be really Trump, and we'll be curious to see what he does with that. We have another thank you that comes from Thrax Balance Games. He says, thank you for your time, R&R team. Thank you, Thrax, for being here. We have one from Mac Boland who says, the fact that Joe let that boy of his to remain in that condition with the resources of the U.S. government, as a father, I'm ashamed. That comes from Mac Boland. You know, I was reading that too. I saw a tweet yesterday from James Novak, which had a good point. You know, he said something to the effect that Hunter Biden is really a broken man. And I've made this case on this channel, right? We've been covering the Hunter Biden stuff, but I've explained here that I have a lot of empathy for the man, because what would happen to any one of us if we were born and raised as a young boy or a young man or a young woman into 47 years of Washington political life? You're raised in the Washington political scene. Joe Biden has been in there for 47 years, raising Hunter Biden up along throughout the entirety of it. And so you would expect somebody as a young boy, as a young man, to just be totally overwhelmed by the toxicity, by the debauchery that takes place there, by the corruption, by the massive amounts of misconduct, all of the problems that you associate with politicians and politics, which are many, basically all of the problems you can relate back to this issue. Hunter Biden was growing up right in the middle of it, right? And Joe Biden, you know, I have no doubt that he loves his son and that he cares for him, but as a father, he was a bit, I would say, negligent in letting Hunter Biden be so just broken as a man. You know, you see some of these pictures, some of these text messages. It's a broken human being, and it's very sad. Now, I have a lot of empathy for him. Doesn't mean I want him anywhere near the White House. Doesn't mean I think Joe Biden should be in the White House, because we don't want a broken son who's already got some evidence of committing malfeasance on an international stage. We don't want them in close proximity to the White House. But it doesn't mean I don't have a lot of sympathy for him, because I do empathize with somebody who's hurting. All right, we see here, we've got, if I was Trump, I would nominate 3 more judges, saying that the Speaker of the House openly calls for expanding the court. So fine, let's do it. Pelosi will oppose expanding the court instantly. Yeah, the issue there is that comes from RAS Illusion. The issue there is that Congress has to actually pass the law that would modify the court. So Trump can say it, but unless Congress does it, it's not going to happen. And the Republicans don't control the House, which I believe is where the bill needs to originate, or at least needs to be approved there. We have John L., who says, I don't have the same level of sympathy. What about the men and women his dad sent to war? Yeah, I agree with that. I mean, yeah. So I think you can have multiple. You can be empathetic and sympathetic for a number of different things and for a number of different reasons. I think just because one person did something that we disagree with doesn't mean that what Joe Biden did doesn't necessarily mean that we can't be empathetic for Hunter's situation. I still don't get me wrong. I wouldn't bring Hunter Biden around my children. Okay, I don't have kids. If I did, I wouldn't bring him around them, right? But I am saying that it is a human who is a broken person, and I just do think we should have a little bit of empathy to people, especially people who have been really put through the ringer, as I imagine Hunter Biden has. All right, when you realize that half the chat is currently indulging in a shooty counterinsurgency fantasy, that comes from Zulu. Michelle's back. She says possibly replace Ray with Rick Grinnell or with McFarland. That would send a message. Why would they want Kamala when they can control Joe much easier? If his brain is that broken, it's best to use him over Kamala. I think Kamala is sort of the backup plan in case that doesn't work out. Mick Levin says politics didn't break Hunter. Losing a mom, sister, brother, all after suffering a head injury did. Yeah, and Mick Levin, I brought that up, right? I said when he was 2, he lost his mom. Brother Bo died, from brain cancer. He's had a rough life a bit. but I do think that the politics probably plays a role. The Nito God says, will you be doing a stream on Election Day? I would like your take as the results come in. Yeah, Nito, we are going to do that. So 2 things on that, and maybe we'll wrap up with this. 2 things on that. Number 1, yes, we are going to be here on election night. I talked to Miss Faith back there. She's going to be here also. And so we're going to start the show at 4 p.m. like we normally do on Tuesday. And we're just going to keep this thing running all night. Okay. I don't know how long I'm going to be here or how much energy I'm going to have on that, but we're going to just keep going and going and going. And in addition to covering just the election, right? We're all going to be wanting to know the returns, who's winning what state. Everybody's going to be focused on the Senate. On the presidency, and then it sort of goes down in tiers from there. The Senate is next. The presidency, the Senate. Then you're talking about House races, and then you've got some of your local races. But what I have started to do is actually gather a lot of the different ballots and the propositions that are on the ballots across the country that are related to criminal justice issues. So I found some from California, some from Arizona, and some from different states where they're talking specifically about criminal justice. Like in Arizona, we have a medical marijuana. We have a recreational marijuana bill that's on the ballot. So don't we want to know a little bit about how that thing is looking? What is criminal justice reform looking like on election night? So we're going to cover those cases as well. So we've got a list of the different ballots, the propositions on the different ballots throughout the states. We're going to be reviewing all of those. We're talking about cash bail, talking about some coronavirus stuff. There's a lot of other interesting issues in addition to the presidency. So we are going to be compiling that. And then Miss Faith is going to be helping me stay organized and get all of this stuff situated. Now, in addition to that, one of the other things that I wanted to see is whether we wanted to actually create a Discord server. So we've actually already done that, but I wanted to see, I've never used one. I've never built one. I don't really know how it works. So Faith and I are trying to work through that. But we've set up a Discord server, and I was thinking, because this time is so long, because we have such a lot of content and time, there are going to be lulls. We have a list of when the polls are going to be closing, and so we'll have periodic updates. But I'm thinking about maybe taking some calls on that live stream. So we were going to set up a Discord, see if if there's interest, see if there's activity over there, and then maybe utilize that as well. So I'd be interested to see what people want to do there. I think it'd be fun. It's one of those moments. This live streaming thing is very, very new to me. I've only been doing this every day for maybe a month now, and it's been a lot of fun, and it's been kind of a cool process for me to kind of sit down and spend some time on these current events issues, and then comment on them and then document them. It's kind of been a weird, kind of like a live journal almost, but we're having conversations. It's been a lot of fun. Yeah, Jay Shopta says you need a couple co-hosts on election night. You can work in shifts. RAS Illusion says you're doing great. Zach Wallace says Discord is very easy. And so we're going to work on putting that together. Yeah, I was thinking about co-hosts. Miss Faith may be able to join in on a call. We'll see. We'll see what happens. We have Faith. He says, hi, Rob. Hi, Faith. Rob, I think the audience would benefit from hearing what treason is legally at some point in a future video. Happy to do that, Mr. Zulu. Happy to talk about treason. Let's see. Have you made any comment on the Breonna Taylor case? That comes from Mule 83. Yeah, Mule 83. You may have joined us a little bit late today, but the whole first part of the show was about Breonna Taylor. So we spent a lot of time on that. Just rewind on back and started over. We talked about the grand jurors finally speaking out, had a lot of clips from a CBS News interview, and I think it's a bit of a good update. So RAS Illusion agrees that treason would be a good topic, and Mac Bolin did a lot of live streaming from 2010 to 2017. We got Mule 83 says, by the way, I do not like Trump, but I'm voting for Trump because of his policies. His policies are great. I've heard that from a lot of people. A lot of people have indicated that. Yeah, Trump personally is abrasive, right? He's difficult. A lot of people don't understand him. They can't connect with that, hardcore, brash, bravado, New York personality. But, it doesn't bother me so much. Michelle Imbruglia says succession would be a good topic. Doing calls would be cool from Luke M. And so on. Yeah. All right. So next live stream, you and Faith should switch seats. That comes from Lorenzo Greasybottom. Yeah. Well, I'll ask her. We'll ask Miss Faith. See if she wants to hop on any of this. All right, everybody. Well, listen, that's it. It's about that time for me. So I'm going to wrap it up and leave it here. We'll be back at the same time tomorrow. We'll be back here at 4 p.m. Arizona time, 7 p.m. Eastern time. Miss Faith and I are going to continue to work on the Discord, and we're going to get some stuff in place for the election next week, and we really hope that you'll be here and join us for that. So if you're not already subscribed, just hit that button, share it with a friend. Like I said, a lot of our videos get age restricted because of the nature of the stuff we're talking about. So if you would share it, or submit it to the forums, to the Reddits, to the Quoras, or whatever it is, you frequent. If you have an account there and you don't mind submitting it, we'd appreciate it, because we're trying to grow the channel. We're trying to engage with more people, because these conversations are very, very important. And I think they're really the foundation for what's going to lead to true movement in the criminal justice system. We need enough people talking about these things, caring about these things, to put the pressure on those in office, those people we elect to go and carry the message forward. We need them to hear us. And so we can only do that with a louder voice. And that's why I want to thank you for being here. And I want to make sure that you're here tomorrow. So hit that subscribe button. We will see you then. One more thing also, by the way, of course, if you know anybody in Arizona who's been charged with a crime, that's what our law office does. That's what our team does. We offer free case evaluations. We have an amazing team. So send them on our way. We'll take good care of them. That's my last plug. And I'm going to wish everybody a wonderful night.